This talk summarises research undertaken by the School of Law at the University of Leeds, funded by the disabled children's charity Cerebra. It summarises research that we've undertaken concerning English social services policies that have the effect of institutionalising parent-carer blame. And in this talk I'll explain what we mean by that concept. Cerebra was receiving many reports from parents of disabled children who were distressed when they made contact with their local children's services authorities, contacted them because they needed support because of their child's impairment. And instead of receiving that support, what the parents were relating to Cerebra and to ourselves was that they were treated as if they themselves were neglectful or abusive, inadequate parents. Assessors would visit their homes, unannounced sometimes, but at very short notice very often, and insist on seeing the child's bedroom and interviewing the children alone. And the outcome of their request for help and these intrusive investigations wasn't medium or long-term support. It was that the parents were then sent on a parenting course, as if the parents themselves were at fault. And this left them distraught and humiliated. So it was decided that the Leeds research unit would undertake a project to assess how prevalent action of this kind was, and if it was widespread, why was it happening? Why do local authorities direct parents of children with disabilities who need support to effectively child protection safeguarding teams, often referred to as multi-agency safeguarding hubs, MASH teams? Why do they do this when there's no evidence in the referral of child neglect or child abuse? Why do local authorities insist that disabled children be interviewed alone, that their bedrooms be inspected, that there be regular home visits at short notice or even unannounced? Why is parenting advice or early help considered an appropriate or indeed the only response? Early help is a short-term intervention, and I'll discuss that later in this talk. And parenting advice seems to locate the problem in the parents rather than the difficulties families have when one of their members is a disabled child with significant impairments. And how can action of this kind, highly intrusive action into people's private and family lives, be justified in terms of their fundamental human rights? We undertook research using two different methods. The first was to analyse the assessment protocols of 143 English children's services authorities. And on that slide, I underline the word English. The reason for that is that this isn't a uniquely English problem. Cerebra had received many referrals from parents in Wales who had experienced very similar treatment, and we've come across treatment not at all dissimilar to this in relation to people's contacts with the National Health Service. So this is a more widespread problem, but for methodological reasons, which we explain in the research report, we decided to focus on English children's services authorities. And 143 of their protocols were analysed, and I'll discuss the findings of that in subsequent slides. But quite separate to that, we undertook a questionnaire survey of parent-carer-led support organisations. We wanted to know what the feeling was about families in relation to their experiences and contacts with children's social services. And we had 92 responses to that questionnaire. So the sort of takeaway points from the research are that this is indeed a prevalent problem, that national and local policies create a default position for those assessing disabled children that assumes parental failings. It starts from the presumption that that is the problem. It's an approach that locates the problems associated with a child's impairment in the family. And as I've said, it's a phenomenon we refer to as institutionalizing parent-carer blame. And a significant reason for this approach is to be laid at the door of the guidance issued by the Department for Education, known as Working Together, and its 2018 iteration, which in our opinion, having looked at it in great detail, is simply not fit for purpose in relation to the assessment and care planning needs of disabled children and their families. It fails to address the distinct assessment and support needs of disabled children for whom there's no evidence of neglect or abuse. It doesn't contain any requirement that those assessing the needs of disabled children have any impairment-specific expertise, something that must be vital if the needs of disabled children are to be accurately identified. Of the 143 local authority assessment protocols we identified, none contained a clear explanation that a different approach should be taken concerning the assessment of the needs of disabled children where the referral was not accompanied by evidence of neglect or abuse. 80% required the assessor to confirm if the child's bedroom had been seen, regardless of whether there was any evidence of neglect or abuse. 87% referred to the need of seeing or communicating with the child alone, again, regardless of whether there was any evidence of neglect or abuse. And none gave evidence or gave guidance to assessors concerning the need for cogent ground to exist before seeking to see a child's bedroom or seeking to interview a child in the absence of their parents. At law, these are intimate examples of family and private life, and the state shouldn't seek to interfere with those without compelling grounds. And very troublingly, only 3% of the protocols that we examined included a reference to the legal duty on local authorities to undertake what are known as parent-carer needs assessments. Of the survey of parent-carer support groups, 86% considered the assessment process to be extremely unsatisfactory and intrusive. And in those 86% of responses, highlighted were such factors as assessors lacking training and understanding concerning the disability-related challenges that disabled children and their families encounter, the intimidating nature of the assessment process, a process that focused on safeguarding child protection and parental fitness rather than the additional support needs that resulted from the child's impairment. And the intrusive nature of the process, with families widely reporting that the assessment visits could take place with little or no notice, and that they were often placed in an impossible position when a social worker turned up at the door. For example, they might have friends and family round, and yet a social worker was knocking on the door insisting on seeing a child for whom there is no evidence of neglect or abuse. The point, I suppose, that one has to appreciate, and I think it must be fairly obvious, is that disabled children are different to children who are suspected of being neglected or abused. And treating disabled children simply as children in need due to neglect or abuse means that they're often denied access to their legal entitlement. There is specific legislation, the Chronically Sick and Disabled Persons Act and the Children Act, that reserves rights just for disabled children. And unless disabled children are assessed as disabled children, they're not going to access these rights that Parliament has set aside for them. And that in itself amounts to unlawful discrimination, and I'll explain that reason in subsequent slides. So essentially what we're seeing is there should be two different assessment routes for children in need. One for children in need whose need arises out of their impairments, for disabled children, and a different route for children in need whose need arises out of neglect or abuse. The disabled child assessment process should focus on the impairment. So it needs to be undertaken by somebody from a team that has got expert in impairment-specific conditions. They'll be looking at longer-term support. Sadly, disability impairment is not a short-term issue. It's often a lifelong condition, and therefore short-term fixes are inappropriate, that you can't cure disability. So the team will look at what support needs are needed, and they will have a plan that will that will be expected to last into the future with annual reviews. And at those annual reviews, if the plan is not working, if the problems that the family experience because of the impairment are not being overcome, then there may be a need to increase that support or change the way the support is provided. And once the child reaches their majority, there'll need to be a plan to hand over responsibility from children's services to adult services, a transition plan. But what our research found was that in nearly every case, except in cases of the most severe impairments, disabled children were actually being channeled down and assessed by the Children in Need team, the team that was responsible for children suspected of neglect or abuse. And often these were called early help teams, teams that were put in short-term, limited interventions to correct poor parenting. And if that failed, then the ratchet would be turned and the local authority would consider taking safeguarding proceedings, Section 47 assessments. And if that failed, then the child could become a looked after child, or there could be care proceedings. The idea of giving a disabled child early help, which is really the service that nearly all the parent care groups were indicating, was what was offered, and also the assessment protocols indicated that that was always going to be the service that was first offered to all families, is entirely inappropriate. As I've already said, disability is not a short-term issue. Early help is appropriate for families where parenting is considered to be an issue because there have been reports and referrals that the child is neglected or abused or being abused. Early help comes out of inquiries by Lord Laming and Eileen Munro into really catastrophic child protection failures, including the Victoria Climbié case. And they recommended that for children suspected of neglect or abuse, there should be some very rapid, short-term, intense support provided to stop the problem escalating and to sort of nip it in the bud, and to stop the children becoming children in need. But that doesn't work for disabled children, because legally disabled children are already children in need of support to address the barriers they encounter because of their impairment. And it's wholly inappropriate to think that counsellors can prevent disability or cure it by short-term, time-limited interventions. And it has the effect of locating the problems of disability within a child's family, within the parenting that is being provided. Although our research was the first to analyze these problems, the prevalence of the problems empirically, and also to identify what was happening in the language of the law. We weren't the first to identify the problem. In fact, shortly before we published the final research report, two official publications drew attention to the problem in powerful terms. One, written by the Chief Social Workers for Adults and the Chief Social Worker for Children and Families in England and published by the Department of Health, said very similar things. A quote you'll see on the slide now says, "Even where the sole reason for contact with children's social care was because of the social care needs of an autistic child, there was a tendency to use the social work assessment as an opportunity to judge parenting capacity through a child protection lens rather than through a lens of social care need. This has long been a complaint of families caring for disabled children." And another report, an interim report of a review into children's services in England, the McAllister Review, said a consistent theme in what the review has heard is that families with disabled children felt that they are navigating a system that is set up for child protection and not support. As I say, the research report articulates these failings in the language of the law. And most obviously, what we are seeing is families with disabled children being subjected to really severe and very troubling interferences with their private and family lives. And such action contravenes basic common law within the United Kingdom, but also the Human Rights Act of 1998. Article 8 of that says that there is a right to respect for private and family life and one's home. And although states can interfere with that right, this interference can only happen where there's cogent evidence to justify it. And as I've already said, in the research, we found no evidence in the assessment protocols to explain this important point to social workers, that if there is no evidence that there is neglect or abuse, then there really is no justification for insisting that the children be interviewed alone, that bedrooms be inspected. The state might argue that, of course, the social worker asks, can I see the bedroom? Can I interview the child on their own? But these are questions sprung upon families when the social worker visits, possibly unannounced or with little notice. And they are pretend choices, because families time and time again say that they are put in an impossible situation because they believe that if they say no, then that will be taken as evidence that they have something to hide, that they are being obstructive. Sometimes when it's put to social services, why are you doing this? They'll say, well, you know, disabled children are at a higher risk of abuse than non-disabled children. And on the slide that I've just shown, there's a link to a paper I've written explaining why that is completely unacceptable. Not only does the data not show that parents are more likely to abuse disabled children than non-disabled children, but also stereotyping of that kind is itself a form of discrimination. It's not only an interference with private and family life, contrary to Article 8. Action of this kind is also discriminatory, because under Article 14 of the Human Rights Act, people can be discriminated if they're the same and treated differently. But it also amounts to discrimination if you are different and you are treated in the same way. And this is what is happening, is treating disabled children in the same way as children who are neglected or abused amounts to discrimination. And that was very strongly said in the European Court of Human Rights case called Clements in Greece, in the year 2000. So what needs to be done? Well, this is the work that Cerebra and the research team at Leeds is working on at the moment in 2022. What we want to do is to change things at the cold face so that families, when they do contact social services, children's services, they get a completely different response. They do not walk away humiliated and traumatized. And that's going to take action at a lot of different levels. And in these next couple of slides, I just summarize some of the things that we are attempting to do. The first, and I think one of the most important things, is to raise awareness of the problem, to use media to explain what is happening, why it's happening, and why it is wrong. Many social workers are going into homes and doing these things that are deeply distressing, but they're not doing it deliberately. They're just not thinking. They're not mindful of the professional problems that they're creating. We're working strongly with powerful independent carer support groups throughout England who are discussing with their councils ways about bringing changes in their policies and practices. Many local authorities accept that this is something that has incrementally developed and needs changing, and therefore have been open to really positive and meaningful discussions with parent carer groups. Those groups are helping them sort of map actually what happens in practice when a family contact the local authority and the routes that those assessments take, the different care processes and pathways. And the families are co-producing training programs with the local authorities so that staff can be aware of these issues, and the new practices and policies that are implemented can then be actioned in a way that best supports families. And families and parent care groups are developing a list of key changes that are required. And this is a work in progress. It's sort of called a manifesto for change, but it's basically about doing things differently. And many of these things do not require huge resources or major upheavals, organizational turmoil. Many of them are sort of tonal as much as substantive. For example, here time and time again, the families are saying what we want is just a listening, a welcoming, an accessible, a kind response, a response that says it must be incredibly difficult to have a child with these impairments. It must be a great strain. Some empathy rather than judgmentality. That disabled children are not referred to the stigmatizing, safeguarding, child protection, multi-agency safeguarding hubs, but to a single point of contact for disabled children. Not necessarily staffed by a disabled children's expert team, but undoubtedly assessed by assessors who have had training and have access to impairment-specific expertise if they lack that. But they must have a grounding, a good grounding in disability awareness, and that might be a sort of continuing education issue for all staff who are assessing in social services. That there is a separate assessment process, one that doesn't use assessments as an opportunity to judge parenting capacity through a child protection lens, to quote the chief social worker for children in England. And a response that focuses on family support, not parental valence. And one that has a web document, one web page that is accessible with succinct, jargon-free explanation of the range of supports available and the importance of parent carers having their needs assessed. we're looking at the issue of accessibility of websites at the moment, and the quality of the web presence for disabled children in local authorities is not good. So I hope I've summarized the research, what our findings are, why we think this is happening, and what needs to change. There will be some more webinars, a number of further webinars as we do move forward with implementation and change. And those will be free webinars, and they will be advertised both by the School of Law at Leeds University and also by Cerebra. So I hope that's been a helpful summary of the work that we've done on this issue, and many thanks for taking time to listen to it.